I'm hugely eager to hear what you've got to say, so I'm not going to yabber on. There are quite a number of people online, I hope, and I think this is the breakout session to be in. It's obvious, isn't it, really? You know, I don't want to put us too high on the agenda, but there we are. ADR or DR, it seems to me, is a very, very important part in the jigsaw of the delivery of justice in the future. And I'm going to focus on just a few things because we have very little time now. But it seems to me that we've got to think about forms of ADR, understanding of them and confidence in them, whether they are delivering justice and how we achieve that, and how we splice them in, both to the system as it is and the system in the future. So that's what I'm going to try to keep us to, and I'm going to be quite ruthless about that because I think we have to be finished by midday, and it's already nearly 25 past, so here we go. First of all, how do we increase understanding of and confidence in mediation? I'm going to start with mediation, but of course there are other tools in the ADR-DR box. And how do you think we do that best? And it seemed to me that there are two aspects of that, and it's both the public and the professions. And I wondered in your answers whether also you would be able, first of all, to draw on your own experience and also experience that there's been of the possession pilot, the family voucher scheme, the small claims mediation. So that's enough from me for the moment. Over to the floor. Does someone want to say something about that? Yes? No? Yes? Wonderful.
So, hi, it's Chris from Legal Aid Practitioners Group. I just wanted to frame this discussion slightly, if I could, with a recognition of the fact that the A in alternative disputes resolution is never really applied to legal aid practitioners, which is the group that I represent. When delivering the services, regardless of the funding mechanisms in place, and I take the examples given by Spike Mullins earlier with the duty scheme services in court, legal aid practitioners employ all of the same principles and skills as mediators and negotiators to try and achieve a positive outcome for their client. So I do think the conversation slightly misses, the conversation we're trying to have today, slightly misses the point that actually practitioners are employing these skills and they are using these processes, even if perhaps not in the formal, understood way that they are by specialist services, to achieve outcomes. Legal aid practitioners are not litigious, and they are trying to resolve these processes irrespective of whether or not they have the correct funding in place, and that's not really been recognised as part of the discussion.
Thank you, and I think that's absolutely true amongst judges too. They wouldn't necessarily recognise that what they're doing is DR sometimes, but they are using those skills along the way, especially with small claims. And I'm meaning by that not conducting their own mediation, but encouraging people to see the strengths and the weaknesses of what they're saying. Certainly in relation to that, I think that it's important that we encourage those soft skills and create some training for them within the judiciary. If we're going to do that, we also need to encourage and bring on board, or at least move forwards together with the professions about how that plays out. Does anyone have anything they want to share with us about experience, about understanding and confidence in mediation that they know about? Hello, yes, wonderful. Sorry, it's just coming.
I'm Camilla Palmer. I run a free mediation service in London called Draw, and certainly and I'm also a judicial mediator and do private mediation, and my experience is really there is a huge lack of knowledge amongst the public and also sometimes amongst lawyers. This is all in the employment field. And so I think it is absolutely crucial that there are videos going out showing what mediation is. And I'm also a member of the Civil Mediation Council. and pushing, and there's a group of us who are put in the workplace group, pushing a lot for there to be more information. And I think everyone says the same. There's just a lot of ignorance, which is, I think, one reason why, in fact, mandatory mediation, to some extent, would be useful, because if people would have to then go to a meeting, and then that would enable them to understand what mediation is, and then make a decision about how it can help. So I completely agree. I think there was a huge lack of knowledge about the process. I mean, I've had people say, well, what happens at mediation? These are lawyers. What happens? The steps. People don't know. So I agree with you.
Thank you.
Thank you very much. So Lizzie Allen from Support Through Court, and I came from a family mediation service in Oxford. I think one of the problems is that when mediation works, it works really well. But I think there is a high expectation that it should work for more people than it does. And I think there's something about, as Camilla says, much more about understanding what it is, but also what it can and can't do. And I think sometimes there's a sort of intention or expectation that the mediation is supposed to work instead of court, and if it doesn't work, then you end up in court. I think if it can be seen as a tool on the journey, and maybe the emphasis on it can reduce the areas of conflict, rather than it's going to solve the whole problem, I think that would be a useful message.
Yeah,
and I think also
it can do, of course, can do both. Yeah.
Well, it can do both, but I think if lay people, if citizens go into it thinking, well, I've got to make this work because I'm not going to get my day in court. Actually, if we can build that messaging and say there are all sorts of ways to try and deal with this. And I do also think there's a lot of messaging that can come from the lawyers, because historically, lawyers' job has been to get the best for their client in an adversarial system. If we can eliminate that and get a sense that what we're trying to do here is get the best outcome for everybody involved, then I think that's a really important push.
It's a real shift of philosophy, isn't it? Yeah, and that's the problem about education. It's a big project, I think.
Hi, I'm Masood Ahmed, Associate Professor at the University of Leicester. I just wanted to build on what's already been said. I think the key thing here, and I'm drawing on my experience on working on the Civil Procedure Rule Committee and on the online civil money claims in particular, which has now an integrated mediation service in there. One of the features that came out of the feedback from some of the users of the pilot scheme was that they didn't understand the nature of mediation. They didn't understand who the mediator was, and some people thought the mediator was actually a judge who was going to give them a binding decision and all the rest of it. So I think overall the key point is emphasizing education and informing users from the outset of the dispute as to the different types and different options, including mediation, placing emphasis on explaining the nature of mediation and who the mediator is, and having that integrated both on the online system but also on the paper system as well. But also going forward, just looking at how mediation can be better sort of integrated within the civil procedure rules. We now have the Lomax and Lomax decision, which emphasize the fact that judges could use their case management powers under CPR 3 to direct people to judicial early neutral evaluation. So maybe revisiting that provision and changing judicial early neutral evaluation to maybe a wider variety of alternative dispute resolution procedures, including mediation, would probably also assist the judiciary in focusing on mediation and on providing other forms of ADR as well. So education, informing from the outset, and also possibly revisiting the rules as well.
I thank you, and I think that somebody else wants to speak there, but before they do, I think that chimes with what Lizzie was saying, that actually, if it were to be part of a new culture which spreads through the professions and through the judiciary and what you can expect, then that moves the whole piece on. Gentleman in the middle.
Patrick Ross from South End London Law Centres. I think one of the other things is there's a need for effective advice for people to get. Without that, people can't really go to mediation. They don't know what they want, what they can get, and what is really achievable. And that's a huge problem.
Yeah, sorry to interrupt you. Two of my further bullet points is, do people feel that in order to make it effective, there has to be legal advice, and there has to be, the second question, which I'm therefore posing to you as well, is there has to be representation at the mediation query.
I think both effective advice is really essential. Take example, court duty housing scheme. You can deal with the thing on the day. You can't deal with the welfare benefits and debt advice, which actually would then help mediate the situation with the landlord and actually get someone staying in their home. So there's many defective failures in the system by the fact that people can't get effective good quality legal advice that is free or affordable for people to have. And then in some cases, some people may be able to mediate themselves. Once they know the facts, they know what their case is worth, they know what the potential outcomes are, they may be able to negotiate. Some people might need help, but the first stage is effective support. And I think that's been shown quite severely in the family courts where people are coming to court unrepresented, and they're just fighting because they have no parameters to start the discussion with. And that's a huge failure in our system.
Can I ask, there's somebody wants to add, but I think that what comes out of what you've said is an additional question, which is also on my sheet, which is we're talking about increasing understanding and confidence in mediation. One can only do that if one also is satisfied that it is achieving a just outcome. And that is part of the picture of what you were saying, I think. Please.
Thank you. Just to add, I completely support the need for a cultural change. And as I was saying earlier when I spoke, we still think as a society of litigation as being the obvious route. There's no common understanding of a different way. I would make a plea that whatever we do in terms of trying to push mediation, we don't do the lawyer thing and we stick to really simple language, because I think we just defeat ourselves when we start getting into complicated places, and we always underestimate other people's legal literacy and we overestimate our own. But the third thing I just wanted to say briefly was there's something about triage, and we talked about the fact that mediation doesn't always work. So we get thousands of inquiries, and we have a range of tools at our disposal to try and move them in which way, from early resolution through to detailed investigation. And we've learned to understand what a mediation appropriate inquiry looks like, and it's often where people have unanswered questions, people are seeking an apology, people don't understand, and then you go all the way to the extreme of somebody who's kind of been there for a long time and has a very hardened view of what they want, and it isn't what's going to be delivered. So there's something about an intelligent approach to it, and that triage process somehow that I think is going to make it work better. Thank you.
Lizzie?
If I can pick up on that, and this may lead on to some of your other questions, but I think one of the other tools that I think is underestimated and how useful it can be is early neutral evaluation.
That's my next heading.
Yeah, because again, picking up on the conversation, lay people, individual people going through the system don't know the structures, they don't know the legal structures, they don't know the expectations, they don't know what they can and can't achieve. So putting them straight into mediation doesn't necessarily help that, as has already been said. Whereas if they've got some steer from a professional who they trust, then actually they begin to narrow the range of what it is they're trying to get at and what they think is a realistic achievement, and then they can work from there. So I think bringing in early neutral evaluation is a really important part of this.
this is crossing all my boundaries, which is very interesting and really helpful. We've got some contributors over here, but before they speak, it seemed to me that this is all part also of the dovetailing issue about whether in fact the judge should be offering ENE, whether the mediator should be court appointed on a list so that there's more confidence in the person. I'm just throwing those out there, and I'd be interested to know what you think. But please, gentlemen over here.
Yeah, sure. Hello, everybody. My name is Simon Davis. Until relatively recently, I was president of the Law Society. But the reason that I'm speaking is just to pick up some words which are used by Lord Wolfson, which is one size does not fit all. I spent my whole career representing sophisticated commercial parties. There is absolutely a culture of seeking to resolve cases. They really do understand exactly what ADR involves. What happens with them is that they have failed to settle. And the reasons, by and large, why they're settling is because the merits are very uncertain. They have relationships often which are ongoing they want to keep. And the risks sometimes outweigh the rewards. These are all proper reasons for why you should want to settle. Improper reasons for wanting to settle is if the system, picking up the points made by Chris, is if the system is so expensive, has so many hurdles in the way, you're going to have a massive trial at the end of it, which far exceeds the kind of trial or hearing you get in arbitration. These are wrong reasons for parties wanting to settle, and I would be very concerned, and I use the word very deliberately, in the context of ADR, if that combined with the practice pre-action protocols, we're going to be adding yet more expensive burdens and hurdles in the way of litigants, and what the litigants want, in my cases, commercial cases, they want to find a system which is cost-effective, rapid, and has a resolution by a judge at the end of it, having heard all the evidence, so not early neutral evaluation. And my own view, based on that experience, is that what we should be focusing on in the system is not so much saying, please keep away from courts, go into ADR, go and do something else, is we should be focusing actually on making our system much more streamlined, using much more digitalization, and having many more judges and shorter trials. That, in the commercial sector, is the way forward, not, I think, saying to people, you don't understand ADR, you should go there. They do understand it and use it when it's most appropriate.
Thank you. A gentleman here, I think, wanted to speak to you.
Thank you. Tony Guys, my company provides a platform, cloud-based platform for the management of ADR. I've had some involvement in civil justice reform over the years, in particular as the past president of the London Solicitors Litigation Association. Two of the key aspects in terms of building confidence in the DR approach, if we are to have much more, as it seems that we are, much more DR everywhere, is many more neutrals. And the same issue about neutrals was encountered in Turkey, which introduced compulsory mediation, pre-action mediation, some years ago, if memory serves, 2016. They didn't have enough mediators, so they trained more. Here, just to echo Simon's point, one size doesn't fit all, and so we'll have many more different types of DR going on, in particular, neutral evaluation, which has been mentioned. And so there needs to be a coordinated focus on training many more neutrals. And my final point is on regulation of neutrals. There is a patchwork of, I would say, so-called regulation. It is underfunded. No criticism of the bodies, but it is underfunded. It is largely ineffective, and it needs to be much more effective to give confidence in the dispute resolution neutrals. Thank you.
Thank you. And so you would say that in order to build confidence, we have to have a regulated and quality-controlled set of mediators. But do you think it would help if they were, in effect, you could obtain a mediator on a list which was provided by the court, for example?
Yes, certainly, but I think it needs to be online. That list needs to be online. It needs to be searchable in a way which I think is much more granular than some lists are available at the moment, which only provide offers between, let's say, civil and commercial mediators and family mediators, for example. But applying to all neutral evaluators and mediators, one needs to have many more categories to reflect the diversity of the claim types.
Thank you.
Thank you.
On the Slido, we have a comment from Chloe Phillips, who says E&E/mediation is now carried out routinely by judges dealing with small claims at Birmingham CJC and some other courts where small claims are listed for dispute resolution hearings. And just to tell you, I've been to numerous places around the country and seen those pilots, or whatever you like to call them, informal E&E and informal mediation going on. Particularly recently, I went to Hastings in that regard, and they're very well. They are often very effective, and we are gathering data as best we can about how effective they are. Two gentlemen over there.
If I may just sort of expand on something I think it's implicit in what you just said, which is to do with both digital and physical proximity of where it's happening as well in the court system. So as part of the CEDA panel I sit on, we do London Central Court mediations, and there is an accepted rhythm, as people probably know, to how those work, which they happen in the building. They generally happen after everything else has closed down, so they're quite late in the day when they're physically there. They translated quite naturally to an online system, but in that case, as I think several people have pointed out, people just don't necessarily know what mediation is, and we were just talking about normalising it. It feels more normal if it's part of the system, both geographically and even on the government website, for example. So quite often I find slightly bemused participants in the litigation, if they're steered to the door that gives them the opportunity for a non-judicial process, will then be utterly converted to it, with all due respect to your ladyship, will be quite grateful for having been in that process and the emotional difference. It doesn't mean they're not potentially going to end up in that system anyway, but for a mediator as well, it's quite helpful to have the spectre of judicial process sitting behind it, the uncertainty, and if you're actually in the building as well, it focuses the mind quite nicely on what will happen if you do not reach a resolution. So I think the point there is digitally as well, though, making mediation part of what happens online alongside the judicial process, I think, is probably quite powerful.
I have to say I agree. I think that part of the confidence issue is having it as an integrated part of the system of dispute resolution. And then one doesn't, as a party, feel that you've been fobbed off and sent into this cupboard somewhere to discuss something with somebody you don't know who he is and you don't know what he's doing.
Professionalising the process effectively, or making it feel like we know it's a professional process, but to some it may not feel like that if it isn't part of the system, as it were. Absolutely.
Exactly, and so that also leads to a lack of confidence inevitably in the outcome, or whether it was an outcome, confusion. I think also Ian wanted to speak. Anyway, to carry on.
Just to add to things that Patrick and Simon have said, and to partially answer your question about representation and mediations, I think there's a few words of warning, because from the perspective of clients that normally receive services through legal aid, they don't make a choice about wanting to be part of that process. It's a process that's often imposed upon them. So whether you educate and have great websites and ensure that people understand and have confidence in mediation is neither here nor there, because they're not choosing to participate in that process anyway. They're not fussed whether it's mediation, whether it's litigation, whether it's an ombudsman. They just want somebody to represent them and try and get them to exercise their rights or protect them from unlawful action. And the key, therefore, is building what Patrick said, is having a well-resourced network of organisations that can be the first point of contact to provide advice about what the options are and how somebody can participate in the process from generally a respondent point of view. When we saw the reduction in legal aid for private family cases through LASPO, one of the biggest, most noticeable consequences of that was an absolute falling off the cliff of referrals to mediation. So the way of people gaining access to mediation and resolving complex emotional family disputes was by referral from a lawyer who was able to filter out the cases that were relevant for mediation, make the referrals where necessary, and assist the people that wanted to go on into a more adversarial process if that was the right way to resolve it. But those resources have been taken away, and until those resources are put back, clients are not going to find their way to mediation in the narrow number of cases where it is appropriate.
Thank you. Lady here.
Hello. I want to emphasize the importance of using, and I'd like to use the word conciliation rather than mediation, because to me mediation means a certain kind of process, whereas conciliation is a negotiated settlement by agreement in some way. And I want to emphasize the importance of doing that before anybody ever gets into a court or issues proceedings. That's the time when you have the best chance of settling complaints, and I don't want to use the word a just settlement, but a fair settlement that suits everybody, I think is what we should be aiming for. And that might not necessarily be the best that it could possibly be for a particular party, but as long as everybody is satisfied with that outcome, seems to me that, and they can live with it and get on with their lives, seems to me that that's what we should be aiming for. And you can't make people go through that process unless you make it necessary, mandatory, for them to have tried that before they ever get anywhere near a court. And that doesn't actually need legal advice, it seems to me. It needs an understanding of what can be achieved, which that conciliation process can give them, an understanding of what the best outcomes for them might be were they to get into a court, and the understanding of what the worst outcomes might be if they could get into a court, so that they have the best chance of understanding what is the right outcome for them.
Thank you. I think, though, inherent in what you said is that they need some parameters. And to have those parameters, you need some advice in order to know, what's the highest and the lowest, and what the building blocks of your dispute are, or is. Yeah, well, query. There are two gentlemen here in the middle who would like to speak.
Mark Bowden from Shelter. Just to respond to the point around, which as you responded for me, on in terms of the importance of advice, I think if a tenant, certainly in the housing context, was sent into a conciliatory situation or a mediation process without an understanding of their legal rights, I think the point would be entirely missed by that process. I think if we were to consider sending people into a mediation exercise, we would also want to know that the mediators themselves were adequately trained in the area of law, because I think that's a key consideration, is gaining the trust of advisors and solicitors to refer clients into that process, certainly where we have responsibilities to act in the best interest of those clients. And I think further, the final point on the landlord and tenant relationship is that there is a power imbalance between a landlord and a tenant. They will often have representation. A landlord will have a solicitor generally, and a tenant will not. They will also have a general deference to a landlord, and they may agree to a compromise which isn't in their interest, simply because of the personal relationship they have with the landlord themselves, rather than through an understanding of their legal position.
Thank you for that. Gentleman there, and I'm sorry, I have seen your hands as well.
Thank you. Simon Mullins, co-chair of Holper. Just to illustrate some of the, one of the difficult and sometimes perverse outcomes that occurs in housing law, to pick up on what Mark was saying, is that there could well be a mediation process in which the inevitable outcome is that a tenant has to lose their home. The right outcome, as Jodie rightly puts it, might be that the tenant loses that home. The difficulty with that is that a person who voluntarily gives up their home can then find themselves without help from a local authority. Now, if that person doesn't know that, then they can be led into jeopardy that they weren't aware of. beyond that, most local authorities will actually require a possession order and will actually require bailiff attendance before any such any homelessness assistance will be given. Now, that's I think I'm often seen as a skeptic about mediation. I'm not really. I think there are aspects of mediation which are incredibly valuable for disputing parties. Not least, somebody mentioned like the day in court. The day in court is not cracked up. Not what it's cracked up to be. And the most one of forgive me, ma'am. One of the most convincing arguments I've heard for mediation is people being able to get their side of the story across. So when conciliation, as Jodie calls it, takes place, that seems to me to be a very positive psychological benefit. However, there are these perverse outcomes which really, really do have to be taken into account. Mark's point about the power imbalance, I know that's sometimes disputed, but I mean, I work with a very vulnerable client group and it is very difficult. I think the last thing to say, sorry I've gone on a bit, but the last thing to say is that I do understand that of course mediation would not, or conciliation, any form of dispute resolution would not land in a static position. It would land in a dynamic system whereby actually the introduction of dispute resolution may change the legal framework over time. The trouble is that you may then have a very difficult interim period. So, yeah, it's quite a dynamic and difficult thing to put through.
Yes. Now, I've got two more people, two, who want to say something. Would you say it very rapidly, please, because we've got, I'm sorry to be so rude, but we've got 5 minutes left, so 1 minute each, and then I've got a series of sort of rapid questions to ask you. So, after you.
Thank you. Matthew Smurden from the Legal Education Foundation, wanting to build on the comments that people who've spoken in favour of outcomes and advice and confidence. Common theme across all of these conversations and earlier was the question of data and evidence. MOJ recently called for evidence in relation to dispute resolution, and as part of our response to that, we commissioned Daisy Agambo from University of Oxford to review what empirical evidence does exist on the impact of mediation on outcomes, experience, and bias. The conclusion was that evidence largely doesn't exist. Certainly not in relation to incentives that motivate parties, not in relation to what works in terms of encouraging people to mediate, and also in relation to outcomes, especially for more vulnerable parties. I would say that therefore a priority as part of this agenda is to focus and carry out quantitative, primary, robust research, and we do have an opportunity to do that at this point in the process.
Thank you.
Good morning, everybody. I'm Grace Duffy from the Department for Housing, Levelling Up and Communities, and I'm the new head of private rented sector dispute resolution and non-traditional tenure. So many of you here that I'm looking forward to speaking to in more detail in the day. We are about to kick off a review of the possession mediation pilot and detail share in due course, of course. I don't think it's much of a spoiler to say that one of the big lessons is going to be about the effectiveness of mediation is going to be significantly influenced by the point at which that is begun. And this is something we're really going to be factoring into our ongoing work. And just kind of wanted to share 3 reflections, I think, things that we've been working on already in the team about our approach to dispute resolution, but which have been really had colour added to it by the discussion today, which is really about this has to be thought of as an ecosystem. It seems there are many, many different problems, many different stages in relationship breakdown, which require different tools in order to resolve them. And secondly, that in order to be really effective, that speaking about relationships, that moving towards something which is seen as not less adversarial in terms of the tenant-landlord relationship, I think is going to be really important because, as JD, you rightly said, actually saving and sustaining tenancies is mutually beneficial in most circumstances. And in order to really do that, the third thing is about a system which is not only just and fair, but is also seen to be just and fair by all parties. And I think that's going to be something very challenging, which, Mark, as you rightly said, where there is often a significant power imbalance between the parties. So on those particular things, they're things that myself and my team will be working on for the next several months. I'm really interested to have conversations with a number of you, your thoughts on those particular aspects.
Thank you. Thank you very much. I'm enormously grateful to you all for your contributions, because this is a very, as you can understand, fluid and developing area, and we're very interested to hear what everybody says about it. We've run out of time. It is now 12 o'clock, and we must obviously give way because Robin is here at the door. I just want you, please, to answer me one question by putting up your hands. Who thinks that compulsory mediation, and I know that this is a stupid question because it depends on the circumstances, but that compulsion, it would be a useful tool? Hands up if the answer is yes. Okay, just so that I can see, hands up if the answer is no. Thanks very much indeed. Unbelievably, that's relatively even. Thank you very, very much indeed. As I say, I very much value all of your contributions. Thank you.